everybody. We are back. We are back. We are back. And y'all, my big sis Glenn came through, child. My phone said ching ching, ching 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 ching. Hey, my big sis Glenn made some loud noise up in this mofo before I could even come on the screen, baby. Thank you so much, big sis. She said, let's go, honey. She made some loud noise with $100 tip up in this mofo. I appreciate you, big sis. I really do. Thank you, thank you, thank you, and thank you. All right. So this live right here, you guys, is important to me. And the reason why it's important to me because I like learning new things or different things, should I say. I don't know about you guys, but I love learning something that I did not know. All right. Now, not that I didn't know that pretrial bond hearing and things of that such exist. I know that exists, but there is a law, okay, in Illinois that I want to go over. And what I understand is it's different in every state. So if you're facing something like this, or you know somebody else that's trying to get out of get out of jail before their trial date, check your state laws regarding this, okay? So with that being said, I do have my disclaimer going across the bottom, and basically it's saying things that I say out of my mouth is based on my opinion and my opinion only. Everything we say is allegedly. We're not trying to defame nobody's character, but I will be going over, I call it a Pretrial Detention Act, but it's really called a Pretrial Fairness Act, which is a PFA, a Pretrial Fairness Act. We're going to cover that, and we're going to talk about how it relates to Holly's situation, okay? That's what we're about to do. Hold on one second. All right, y'all know I have to drink my little water before we start. Thank you, Lorraine. She said, today is my 55th birthday. Happy 55th birthday, Lorraine, girl. 55 years old. Beautiful. Happy birthday, baby. Then my big sis Glenn said, we are back. Check your coffee link. I appreciate you, big sis. Lady V, I appreciate you, darling. Sassy D, hey, Amore and chat. We back, and we is. And then my girl Joanne says, let's talk about it again tonight. Yes, so let's talk about this, right? Like I said, it's called a Pretrial Fairness Act, okay? Now, again, why do they even have this? Well, the reason being is because when they did away with the cash bond, they said, we ain't letting nobody out. We don't want no more money, because that's all the bonds are. Bonds ain't nothing but, in my opinion, it's just a way to take your money, because it really doesn't go toward nothing. It don't go toward your lawyer fees. It don't go toward your stay if you get locked up, like your food, your snacks, or your commissary. It don't go toward none of that. It's literally free money, right? Free money to the state and less money for you or your loved ones. So that's what a cash bond is, right? So the state of Illinois said, we're doing away with cash bonds. We're not about to be taking nobody 10% no more, right? However, after they made that, after they put that in effect, a year or so later, they came back and was like, wait a minute, we need to look at this. We need to readdress this, okay? So basically it says, hold on. It says, when we got rid of the cash bond, Illinois eliminated the traditional cash bail system statewide, okay? It says a person's ability to pay is no longer a reason to hold them in jail pre-trial, right? Because the unfortunate people, or the people that didn't have them coins, they would be in jail until they were able to go before the judge, right? Because they ain't had no money, and people, loved ones, wasn't about to cough up no $25,000, no $30,000, no $40,000 to get people out, because they were setting these bails real high, and wasn't nobody about to go cash their savings in to get somebody out when it's not, it doesn't even go toward your lawyer fees or anything like that, right? So they abolished the whole cash bail system and said, by law, we will no longer hold you for the reason of you not being able to pay, okay? So presumption of release, the law created a default rule that most defendants should be released pre-trial, absent specific conditions. So basically they said everybody should have an opportunity to be released pre-trial with conditions, okay? And the judges are the ones that set the conditions of the release rather than basing release on money. The judge can say, yes, you can get out with these conditions, or no, you cannot get out under no conditions, okay? Now let's go a little further, right? Now, it says limitations. Let's talk about the limitations on detention. Only individuals charged with certain serious or detainable offenses may be subjected to detention hearing. Meaning some people won't even have to go. Some people will get out on their own reconnaissance, right? Some people don't even have to do this. They just let them out, right? They hold you for a couple of hours and then they just let you go. You don't even have to have a detention hearing. But serious offenses, right? They want you to be able to have a detention hearing. Prosecutors must file a petition and prove by clear and convincing evidence, that detention is necessary due to a flight or threat to the public, okay? Now, that's a prosecutor's job. They basically must convince the judge through clear and convincing evidence that detention is necessary. And why is it necessary? Due to a flight risk, meaning that you may flee the state or the country, or you are a threat to the public. You are a threat to the public. Now, rights to cancel at release decision. The PFA, which is the Pretrial Fairness Act, guaranteed the rights to cancel at the initial appearance where pretrial release decisions are made, which means you can have a lawyer, okay? You can go get you a lawyer, right? And that reduces the racial or economic disparities. So they're basically saying, we will even allow you, if you can't afford it, a court-appointed attorney to stand right beside you during detention, pretrial detention, okay, hearing. During the hearing, they will give you, if you cannot afford an attorney, they will give you an attorney to stand beside you in the detention hearing, all right? So in other words, Illinois law doesn't guarantee release for everyone, but it sets a presumption of release and limits detention to specific cases where a judge finds a real threat or flight risk after a hearing, okay? Now, let's talk about how this differs from the old bail law, all right? Before they even set this Pretrial Fairness Act in effect, the judges offered set cash bail's amount. People unable to afford bail stayed in jail regardless of their risk. Now, let's go back a little bit. The state of New York. There was a kid that was, it was alleged that he stole a book bag, okay? And he got locked up. Now, before he was able to even go before a judge for his detention or cash bond hearing, he was literally in jail for like 2 to 3 years before that hearing ever took place because he kind of got lost up in the system, okay? During that time that he was waiting to go to court for a bond hearing, you guys, do you hear me? He was waiting to go to court for a bond hearing. It took him 3 years, 2 to 3 to get there. While he was waiting just to go to court, just to go before a judge, this young fella was raped. This young fella was beat. This young fella was tossed around in jail. Now, if I'm not mistaken, I want to say the guy was pretty young. I can't remember the age, but he was pretty young. This traumatized this young fella so bad that when he eventually got out, now he stole a book bag, okay? And I hope I'm telling the story right. By the time he got out, he ended up committing suicide. Why? Well, because the small thing that he did to go to jail, because he wasn't afforded the opportunity to go before the judge. He didn't have the money to get out before he was able to go before the judge. He was violated. Okay. This was out of New York. They sent him to Riker Islands. Okay. Riker Islands prison. So anyway, which is a horrible ass thing. So Illinois got rid of their cash bail so that people that could not afford it or their parents was just not going to dish out no savings or go ask around for money or just maybe didn't have it, right? They were not going to hold them until they trial because they was broke, basically, all right? Now, again, people unable to afford bail stayed in jail regardless of their trial. The money not risk often determined pretrial freedom, which means people that had money was going home to their families, and sometimes the crime was absolutely the same. But they were being able to be released, go around their children, go around their family, go around their friends, when the people that didn't have money committed the same crime was locked up. All right, now that's the old version of the cash bail. Under the new one, no cash bail. They don't want your money. Judges are the ones that assess the risk. They're the ones that set the release conditions. Prosecutors must actively seek detention. Now listen to what I just said. Prosecutors must actively seek detention, meaning that prosecutors, in order for a defendant to stay locked up, prosecutors must ask for it in writing, okay? Now, Illinois' Code of Pretrial Detention. Illinois law still includes statutory provisions governing when the state may seek denial pretrial release and what standards apply. But those provisions are now operated under the modern Pretrial Fairness Act framework, meaning detention is the exception, not the rule. All right? Again, it is the exception, not the rule, meaning that everybody is not going to stay locked up. All right? Now, let's go a little further. Hold on one second. Let's talk about what a pretrial detention is. It's not a conviction. So at detention, prior to your trial, the state attorney is not trying to discover whether you are innocent or guilty. They don't do that there, okay? They don't have to bring no evidence or anything like that or whatever, because again, this is not where they prove your innocence. So it is not a conviction. It is not a punishment. It's not based on whether you're guilty or you're innocent. The sole purpose, court appearance plus public safety. That's it, right? They're literally trying to determine if you are a threat to the public. Now, the state does have a burden of proof, and let's go over it. The state's burden, the state must prove detention is necessary. The defendant does not have to prove innocence, and the court requires clear and convincing evidence, not speculation. The burden is on the state, not social media. All right. Now, let's talk about the factors the judge must consider when the state attorney present their clear and convincing evidence. Now, when I say clear and convincing, hey, David, when I say clear and convincing, that doesn't mean they have to see a video footage. That doesn't mean they have to see photos. They can literally just hear a statement from the state. It needs to be clear and convincing, meaning clear, the judge understands it, and the judge is convinced. Let me say that again. It must be clear and convincing. Clear, the judge understands it, and convincing, the judge is convinced. All right. Let's start breaking down what the judge must consider. The judge looks at your prior criminal history or your lack of. Look at threats or pattern of violence. Look at the ability to follow court orders, strength and consistency of the evidence, and self-defense indicator. Now, this is where you separate legalities from emotions, okay? When I say self-defense indicator, in Holly's case, the defense was saying it was self-defense. The judge, the detention judge, just heard the state attorney say that there was a fist bump celebration. That was just one of the things that was said. That was just one. Matter of fact, let's go over what was said. That's what we're going to do. Let's go over what was said, because the fist bump was just one thing. And you have to understand, when I even went back and heard some of the things that was said or was supposedly have been said, I was taken aback. I want you to hear it straight from her mouth, though. Let's do that for a second. Give me 1 second. We're going to hear straight from Tia's mouth what was said in the courts. This is the transcript that made what's her name? Tia Irwin, I think. Irwin's. Okay. This is what made the judge say, hell no, she can't go nowhere. Give me a second. When y'all hear what she claimed, I mean, not she claimed, because I can't sit here and blame this on Tia, but Tia read off the proffer. And when she read off the proffer, y'all, I was blown away. When y'all hear some of the things that the judge heard on the first bond hearing, you will clearly understand why Holly is still locked up. And let me go a little further and explain that there was no evidence at the time. However, you will hear her say that the CTA footage corroborates the witness. Now, that was said as a strategic way, because it is incorrect. It's incorrect for what people believe it was. Let me just say that. When she said that, when she read off that the state attorney says it corroborates the witness, basically what she's saying, it corroborates the witness being in the area, okay? But it does not corroborate what the video footage does not corroborate what the witness saw, because as we all know, that evidence shows that the video footage shows that it does not corroborate what the witness saw. There's no way that she saw or heard what she says she saw. All right, I'm going to read off the state proffer. All right, it says, all right, some of the stuff we already know, like the defendant Holly Johnson and the victim Romika Blackman each had a child with witness number 1, which is Carlos. All 3 were involved in a dispute near a school on the morning of the incident. All right, so prior order of protection in December 2024, Johnson sought a stalking no contact order against Blackman. Johnson alleged Blackman made verbal threats through Johnson's family members. No allegation of physical violence was made in that petition. The order was granted in July 2025. The order was never served on Blackman. Okay. Now, she says never served on Blackman, but we know that that's not a factual statement, because it was served in June, but it made, the way it was said, the order was never served on Blackman. It kind of left speculations, you know what I'm saying, for the judge to probably think that it was never served, like she did not know anything about this, but that's not the case. The final order was not served. However, Blackman was definitely aware of the order. All right. Now, the events on the morning of the shooting. Okay. On September the 8th, shortly after 8:30 a.m., witness number 1, which is Carlos, drove a black Mercedes SUV. Johnson was in the front passenger seat. Johnson's 6-month-old child was in the rear seat. The Mercedes was parked 2 car lengths in front of Johnson's black Chevy Cruze. See, that's wrong information right there. The Mercedes was parked 2 car lengths in front of Johnson's black Chevy Cruze. So already we know that that is not true. And the reason why that is not true is because Carlos' car was not directly in front of Holly's car. It was in front, but to the left of it. It wasn't directly in front. Do y'all understand what I mean by that? It was not in front of her car. It was more like to the left of her car, but it still was like, let me just show you this picture. So Holly car is the one over with the, let's just say the yellow, the red. And then Carlos' car was in front of the white car. Okay, so it wasn't directly in front of. All right, so anyway, I don't know how much that makes a difference. But it says Johnson and witness number 1, which is Holly and Carlos, transferred the infant from the Mercedes into Johnson's Chevy. Romika arrived separately in a white Kia sedan. Romika had just dropped her 6-year-old child off at school. Romika double parked behind the Mercedes and exited her vehicle. Now, it says she double parked behind the Mercedes, okay? Now, double parked behind the Mercedes, basically, she blocked Holly in, basically is what she did, all right? Now, the initial argument, it says an uninvolved witness observed Holly and Romika arguing in the streets. Now, that's witness number 2, apparently, the DoorDash guy, all right? An uninvolved witness observed Johnson and Romika arguing in the street. Witness number 1, which is Carlos, was standing between the 2 women, arms extended. Carlos pushed Johnson away from black men. That's what this says. Carlos pushed Johnson away from Romika. Now, I don't know how he pushed Holly away from Romika when he was in between the 2 of them. Okay? It says Romika was observed unarmed, standing stationary with her arms crossed. Really? Really? So, meaning Romika was observed unarmed, which how they know what she got? How do they know what's in her hands if her arms is crossed, right? But she was observed unarmed, standing stationary with her arms crossed. Now, it doesn't say how Holly was observed. I wonder, did Holly have her arms crossed, or did Holly have a AK-47 in her hand? It says CTA bus video captured the argument. And that's not true. CTA bus did not capture the argument. Now, in my opinion, what I think they was trying to say is witness number 3, which we calling her 9 seconds, was on the CTA bus and captured the argument. So she claimed. But the CTA bus, it says the CTA bus video captured the argument. That is not true. That is false. They do not have video footage of the argument. Again, they do not have video footage of the argument. Now, let's continue. Johnson walked toward the driver door of her Romika's Kia. Okay? Now, it says Holly walked toward the driver's door of Romika's Kia. Carlos stood immediately outside the open driver's door. Another witness observed Carlos swing the car door into Romika's multiple times. A witness called 911 reporting black men was being struck with the car door. After the 911 call, Romika entered her vehicle. This is what's read in front of the court, y'all. Now let's talk about the threats and weapons. 2 witnesses observed Johnson approach Blackman's car again. Now, I don't know who those 2 witnesses are because only witness number 3 put that in their statement. Again, let's say that. This is what was read. 2 witnesses Oh, I know why it said two witnesses. It says two witnesses observed Johnson approach Blackman's car. Now, y'all just remember that. I'll tell you later what I meant. Just remind me later, like after the 7th or whatever, or something. And then I tell you what I was going to tell you. So anyway, so witnesses heard Johnson making threats toward Blackman. Another witness saw Johnson retrieve a handgun from her Chevy. Now, it sounds to the judge like I'm talking. It says, this is how it reads to the judge. Two witnesses observed Johnson approach Blackman's car again. Witnesses heard Johnson making threats toward Blackman. Another witness saw Johnson retrieve a handgun from Chevy. So what does that sound like? That sounds like a lot of witnesses seeing Holly as the aggressor. Again, I'm going to read that again. It says two witnesses observed Johnson approaching Romika's car again, meaning that she did it before and she's doing it again. So this is what the judge is hearing. Two witnesses observed Johnson approaching Romika's car again. Witnesses, okay, meaning more than one, witnesses heard Holly making threats toward Blackman. And then another witness, that sounds like a whole different person, right? Another witness saw Johnson retrieving a handgun from the Chevy. Now, with what I just said, that sounds like about 4 or 5 different witnesses collaborating that Holly was the aggressor, right? But in reality, based on their own statements, none of them are collaborating each other. And out of the 4, only one witness claims she saw the incident. Now, again, DoorDash drivers did say he saw them two arguing and and Carlos is standing in between them. But he admits that he did not see no fighting. He admits he did not see the weapon being fired. He didn't even see a weapon at all. So we know because of that, even though it sounds like it's multiple witnesses, only one witness, which is 9 seconds, right? Witness 3, 9 seconds is the only one that speaks of all of this bullcrap, right? Okay, let's continue. So it says Johnson was then observed standing on the sidewalk with the firearm. A witness heard Johnson threaten to shoot Blackman. A witness, right? And then it says witness number 1 warned Blackman that Johnson had a gun. So I'm here to tell you, of all those things that I just read off to you, which is number 1, 2, 3, 4, 5, 6 things I just read off to you, all of that came from witness number 3. She said every last one of that shit, except for the first one, though. 2 witnesses observed Johnson approach Blackman. We'll discuss that another day, okay? Just remind me, and we'll discuss that another day. Now, let's continue. Blackman, which is Romika, exited her vehicle. Carlos approached Blackman from behind. This is what the judge is hearing. Carlos placed Blackman in a chokehold. Carlos struck Blackman while restraining her. Romika was observed unarmed, hands raised, trying to break free. This is what the detention judge heard. Let me say that again. Romika exited her vehicle. Carlos approached Romika from behind. Carlos placed Romika in a chokehold. Carlos struck Romika while restraining her. Romika was observed unarmed, hand raised, trying to break free. Let's continue. Let's talk about the shooting. This is what the judge heard. Johnson pointed the handgun at Romika. Romika broke free and took steps away from Johnson. Hold on. Let's go back. This is what the detention judge heard. Johnson, which is Holly, pointed the handgun at Romika. Romika broke free and took steps away from Johnson, which is Holly. Holly advanced toward Romika. And then Holly fired multiple gunshots at Romika. Witnesses, again, more than one, witnesses noted a pause between the first shot and subsequent shots. One witness heard a shot, a pause, and then two more shots. Romika was struck multiple times and collapsed. Let's continue. This is what the judge heard. Let's talk about the aftermath. Witnesses, more than one, moved Romika's body slightly west away from traffic. Yeah, y'all heard me. This is what was said at detention hearing to the judge. Let's repeat that. Witnesses, more than one, moved Romika's body slightly west away from traffic. A witness observed Holly and Carlos fist bump after the shooting. Police arrived and observed Carlos covered in blood and Holly with blood on her. Holly was positively identified as the shooter. Holly admitted to the shooting. Police recovered a loaded 9mm handgun from Holly's Chevy. 3 spent shell casings were recovered. Ballistics confirmed all casings came from Johnson's firearm. Romika was transported to the hospital and pronounced deceased. Now, statements by the defendant. Holly refused medical attention. Holly claimed self-defense. Holly acknowledged this was the first time she had ever seen Romika in person. Holly had a valid FOID card and concealed carry license. Holly had a prior run-in with the law. Now this is what's told to the judge. Okay? Now, let's talk about the state's detention argument. The shooting occurred in broad daylight near a school in a public setting with children present. Holly was undeterred by witnesses. Multiple 911 calls were made before and after the shooting. The state argued Johnson posed a real and present danger to the community. The state asserted no conditions whatsoever, none, could mitigate the danger, justifying detention. Okay? Now, I want to go a little further. This is what the judge is hearing. Okay? The defendant, Holly Johnson, is charged with first-degree murder. The proof is evident and presumption is great. On the morning of September 8, 2025, the defendant engaged in a verbal dispute with the victim, Romika Blackman, in a public street near a school during morning drop-off hours. Multiple civilians, witnesses observed the defendant acting aggressively and approaching the victim on more than one occasion. Okay, you heard me when I say multiple civilian witnesses. We'll talk about that. Witnesses observed the defendant threatening the victim, retrieved a firearm from her vehicle, and pointed the firearm at the victim. The victim was unarmed. Despite the presence of witnesses, children, and a public setting, the defendant fired multiple gunshots at the victim. Witnesses reported a pause between the first shot and subsequent shots, indicating deliberation. The victim was retreating at the time she was shot. This is what the judge heard, y'all. The victim was retreating at the time she was shot. I'm about to say that once again. The victim, Romika, was retreating at the time she was shot. Now, I'm going to say this. I know that's a lie. Y'all know that's a lie. Everybody and their grandmama know that's a damn lie. Why do we know that's a lie, y'all? Why do we know that Romika was not retreating at the time she was shot? Why do we know that's a lie? Well, one, she ended up by Holly's car. Two, the blood splatter from Romika's body was on Holly's car. And three, the shots was forward to backwards. The bullet wound by the autopsy report said that they entered the front to the back. Front to the back. She was not retreating at the time the shots was fired, but that's what the witness said, and that's what the state of attorney said to the judge. Let's continue. After the shooting, witnesses observed the defendant and another individual engaged in a celebratory conduct. The defendant was identified as the shooter, admitted to the shooting, and a firearm recovered from her vehicle was forensically matched to the shell casing at the scene. The state submitted that the defendant conduct demonstrated a complete disregard for human life, public safety, and the authority of law. The offense occurred in broad daylight near a school in front of multiple witnesses and involved repeated gunfire. Based on the nature of the offense, the strength of the evidence, and the danger posed to the community, no conditions or combination of conditions can reasonably ensure the safety of any person or the community. Therefore, the state respectfully requests that the defendant be detained pending trial. Okay? Now, because the state attorney read those things and stated it to the judge took it as clear and convincing evidence. Okay? He didn't have to show no video. No video was shown. But a video was mentioned. And what did it say? Let's see exactly what it said by the video. I want to say it says CTA captured the... Let's see. Hold on 1 second. So this is what the judge heard. Video, it says CTA video captured the incident. CTA bus video collaborate witness statements. That's what this said. You see the strategic way the state wrote this? It said the argument between the defendant and the victim was captured on CTA bus footage. The positioning of the parties near the open driver's door of the victim's vehicle was captured on video. The footage shows the father standing between the two women, the defendant approaching the vehicle. The video evidence was cited alongside multiple eyewitness accounts. Right. How do I know that that's not true? The defense attorney, Ari, she did a motion, and we already went over the motion, but let me just skim through the things that she defended, because that is her job, right? She has to defend what they are accusing, right? So this is what she said. This is how she answered the state's argument. She first started off with, the state must prove by clear and convincing evidence. Proof is evidence. Presumption is great. The defendant poses a real and present threat. No conditions could mitigate that threat. Ari's response, the defense response to the state. The state relied on allegations and narrative, not reliable evidence. This is what the defense attorney is saying to the courts, okay? The state attorney relied on, hold on, let's go back. The state relied on allegations and narratives. Allegations and narratives. Not reliable evidence. Detention cannot be based solely on the charge of first-degree murder. Illinois law requires individualized facts, not generalized fear. All right? It says, defense response to the state intentional murder theory. The state cannot show intent to kill without lawful justification. The defense assert the shooting occurred in self-defense of the defendant and her 6-month-old child. It says key self-defense elements. The defense claim were met. Prior threats by the victim, intimate danger, defendant not the aggressor, reasonable belief of harm, force necessary under the circumstances, right? It goes on to say, the defense attorney responds to the state minimizing the protection order. The defense attorney says the order of protection was requested December 2024, granted July 2025, served on the victim in open court. So right there, she says, you said it wasn't served, and I'm telling you it was. It was served on the victim in open court. And then it goes on to say the victim knew contact was prohibited. Court transcripts showed the victim acted aggressively during the restraining order proceedings, okay? The defense said this was no paranoia. Fear was judicially recognized, meaning legally recognized, okay, by a judge. A judge recognized her fear just 2 months prior. It says the victim violated the spirit and allegedly the terms of the protection order by approaching Holly. All right. Then it goes on and say, this is what we have in evidence. Now, this is major, y'all. This is major because this is what the defense says that they have in video evidence. The defense attorney responds to the state reliance on video. And this is what she said. No video exists of the actual shooting. No video exists of any fist bump. No video exists of verbal threats by the defendant. No video exists of door slamming alleged by your witnesses. The POD camera and CTA footage do not capture the shooting itself. Defense goes on and say, the state attorney improperly suggests video corroboration where none existed. She is basically calling the state attorney a fucking liar. Let me say that again. The defense attorney says the state improperly suggests video corroboration where none exists. So Attorney Ari tells the judge that the state attorney improperly, tell me what improperly means to you. Attorney Ari says the state improperly suggests video corroboration where none exists. Then she goes on to say, without video of the shooting, the state relies entirely on witness recollection. That is insufficient for clear and convincing evidence. So when I tell you she flipped that video corroboration argument on his head, she turned it upside down. She smacked it all the way back is what she did. Let me say that again for those all the way in the back, baby. Attorney Ari says the state improperly suggests video corroboration where none exists. None. Okay, this person said, why are you angry? Okay, let me just go on and sit you in the corner. We ain't got time for that. This 2026, not my chat. Again, it says the state improperly suggests video corroboration where none exists. So basically what the defense attorney is saying is, state attorney, you went before the judge on December the 4th. You told the judge on December the 4th that CTA bus footage corroborate your witness? Why, when you turned over discovery, and I went through every last one of these videos, and I don't see no argument, I don't see no door slamming in nobody's back, I don't see no fighting, I don't see no advancement, I don't see no threats, and I damn sure don't see no shooting. How dare you? How dare you go before a judge on December the 4th and fix your mouth to tell the judge that the video footage corroborates your witness? You improperly suggested that. Improperly. You improperly suggested that video corroborations was there, and there is none, no existence of it. Okay? She says, without the video of the shooting, the state attorney relies entirely on witness recollection, her damn memory, what she claimed she saw. The state relies entirely. Now, I'm telling y'all this. This is what Attorney Ari is saying. If there is video footage, Attorney Ari would not put this in her motion. She would not be presenting this before a judge. Now, let me tell you what the judge is going to do. The judge is going to look over at the state's attorney and say, where's the video footage that you said corroborate your witness? Where is it? Where is it at? You said you had video footage to corroborate what your witness said. Where is it? And the state gonna be like, what I had meant, what it said was, Attorney Ari, the defense attorney, says the state improperly suggested that, where none exists. Now, I'm going to tell you this, that this is Talk About It with Amar. You can listen to whoever you want to listen to. But I'm telling you, don't believe the hypes. For anybody that's telling you that there is video footage, when you have a defense attorney that just flipped that shit on his head. Okay? She goes on to say, that is insufficient for clear and convincing evidence. You cannot have clear and convincing evidence to no judge when you basically came forward and improperly suggested. And I love the way she said improperly suggested instead of just saying you flat out lied. She says you improperly suggested. I'm going to do something right quick. I know I don't have to, but I'm going to do it because I want to, okay? I'm going to tell you what I'm doing in a minute. Just because I want to. Instead of saying that the state lied, okay? I asked ChatGPT to list many ways that you can say improperly suggested, okay? Many ways that you can say that. Let's go. And I'm gonna tell you, ChatGPT being nice and shit, because it ain't coming out and saying what I would want to say. But anyway, this is what it says. It says it goes on to say unfairly painted a narrative, injected speculation into the record, overreached beyond the evidence, framed facts in a misleading way, distorted the significance of the evidence, stretched the facts, okay, goes beyond what the proof supports, impose meaning that isn't established. They ain't all. It's a hint at something that isn't proven, leads people to believe something that wasn't shown, make it sound worse than it was actually proven, plant an idea without backing it up, pushes a narrative without proof, tries to get people to assume, suggest guilt without showing it, add meaning that isn't there, creates a story instead of sticking to the facts. And then it goes on to say, when I said, give me a different variation of improperly suggest, it says unfairly implies, inappropriately infers, suggests without evidence, creates an unsupported inference, invites the courts to assume facts not in evidence, improperly characterize the conduct, advances a conclusion not supported by the record, introduce speculation rather than proof, relies on inference instead of admissible evidence, attribute intent without substantiation, mischaracterize the evidence, exceeds what the evidence reasonably shows. So again, what did I say? The defense attorney basically says that the state improperly suggests that there was video footage when none exists. When none exists, she basically saying you told the judge something that's clearly not true. Okay? That's not true. Now, let me get back to it. She said that is insufficient for clear and convincing evidence. Now, let's talk about the U-turn and the blocking the vehicle. Attorney Ari responds to the state's timeline. And she says, street camera video shows victim made a U-turn, double parked her car, blocked Holly's vehicle. The encounter was not an accident. All right? Goes on to say the victim initiated the confrontation. Blocking the vehicle removed the defendant's ability to retreat. This supports self-defense and negate aggression by the defendant. Okay? Now, this says video footage shows this. And she listed as an exhibit, meaning that she is going to be showing this in court. Okay? She's going to be showing in court. It says street camera video shows. And let me reread what it say it shows. It says it shows victim made a U-turn, double parked her vehicle, and blocked the defendant vehicle in. So it doesn't matter what anybody say about Holly was not blocked in. Video footage proves that she was blocked in. Now, let me explain something a little further, okay? That street camera video that the defense attorney will be showing on the 7th of January, it shows before Carlos moved his vehicle. It shows before the paddy wagon came. It shows before that. Yeah. It shows the real deal Holyfield. You want to know why? Because it shows her parking her vehicle, double parked her car. It shows that. All right, let's continue. Now, the defense argues that the victim initiated the confrontation, so she was the aggressor. Defense argued blocking the vehicle removed Holly's ability to retreat. And this supports self-defense and negates aggression by the defendant. All right. Now it goes on to say, let's talk about your star witness. Attorney Ari said, let's talk about, now I'm putting words in her mouth right here when I say this, but let's talk about your star witness. Let's break down 9 seconds right fast. Shall we? Attorney Ari says, your star witness was on a moving CTA bus, wearing large headphones over her ears, was approximately 350 to 400 feet away from the crime scene. She had obstructed views, was moving away from the scene when she exited the bus. The defense attorney goes on to say, bus video CTA video contradicts your witness claimed reactions and observation, meaning that I got your witness on tape, on video. I got her on video, and that video contradicts your star witness. It contradicts the claim reactions that she claimed and her observation. So basically, she says she could not reliably hear any threats. She could not clearly see any key events. Her statements are uncorroborated and inconsistent. Yeah, that's what Attorney Ari is saying to the states. How dare you bring this girl up here without doing your entire homework to find out that she was on a moving bus wearing headphones and only glanced out the window for 9 seconds. She didn't call nobody. She didn't open her mouth in awe after claiming that she just witnessed a domestic violence dispute. A man aggressively beating a door into the back of a woman. She didn't tap nobody on the shoulders. She didn't look shocked. No reaction whatsoever is what Attorney Ari is saying. She says she looked out the window for 9 seconds, turned her head, looked forward, and continue her ride. And got off the bus. And guess what else she did? She went in the opposite direction of the scene initially when she got off the bus. This is what she's going to show on next Wednesday, the 7th, okay? So Attorney Ari says detention cannot rest on unreliable eyewitnesses. Your eyewitness is unreliable. Why? Because there's no way that she saw what she say she saw. There's no way she heard what she say she heard. You allowed this, state attorney. You allowed this. Then she goes on to say, now let's talk about this fist bump allegation. Let's talk about it. Let's talk about this fist bump allegation right fast. Let's talk about it. She says, you improperly suggest that there was a fist bump. But where's the video? Where is the video to back up that claim? Oh, you got it from witness number 9 seconds? Is that who you got it from? The one that could not have seen what she say she saw? The one that could not have heard what she say she heard? Oh, you got it from her? Is that who you got it? You got it from the unreliable eyewitness? The uncollaborated and inconsistent witness? She said, let's talk about this video. There is no video of a fist bump. And then she even further says, I have proof that your uncollaborated, inconsistent, unreliable witness. I have body cam that proves when she initially gave her statement to the police on the scene, she didn't mention not a damn word about a fist bump. But now you want us to believe that there was a fist bump? Attorney Ari argues that the allegation is speculative and prejudicial. She says it improperly suggests malice or celebration. Again, she used the word improperly suggests. I say lies, but she say improperly suggests. It improperly suggests malice or celebration where there was none. There was no malice. There was no celebration. She says, there is no video footage of that. And she says it cannot be relied on for detention. You cannot keep someone locked up because you claim that there was a fist bump. There is no video footage that shows a fist bump. And your shady ass witness is not reliable anyway. She don't say that, but I'm saying that, okay? Then she goes on and talk about the defendant background and risk assessment. She said, it says, okay, you saying that Holly is a danger to the community. Well, Holly has no violent criminal history. She has minor non-violent misdemeanors. She has no pending cases, and she has strong community ties. She's pregnant and the primary caregiver of her baby. And also, her PSA scores indicate low risk of new criminal activities and failure to appear in court. Now, what does this do? It undercuts the state claim that she is an ongoing danger. She's like, no, how? How is she an ongoing danger? How is she? How is she an ongoing danger? Because the things that you just told the state don't make no damn sense. You gave him a bunch of fluff. You tried to sprinkle sugar on some shit, and it didn't stick with your unreliable witness, okay? So it undercuts the state claim that she is an ongoing danger to the community, threat to anyone, okay? Now let's talk about the condition of release that was ignored by the state, because the state said under no condition can she be released. Under none. She too violent to be released under any condition is what the state relayed to the judge. But then Attorney Ari says the state failed to show why electronic monitoring, home detention, no contact order, GPS restriction would not mitigate any risk. The state didn't even mention that shit. The state just came out and said, I ain't no conditions. Not now one of them will work. So Attorney Ari came back and said, okay, state, prove why electronic monitoring will not work. Prove why home detention will not work. Prove no contact order will not work. Prove a GPS restriction will not work. Prove it. Because you didn't on December the 4th. You failed to show why none of these 1, 2, 3, 4 things, why it ain't gonna work. All of these are conditions of release, but you ignored them. You didn't even tell the judge why electronic monitoring won't work. It worked on other people that's accused of first degree. Why home detention ain't gonna work? It worked on other people accused of first degree. Why no contact order won't work? It worked on other people accused of first degree. Why GPS restrictions won't work when it worked on other people accused of first degree? Then Attorney Ari went on and said, Illinois law requires considering conditions. So Attorney Ari said that it is by law. The law requires considering condition. And she says the state relied on generalized fear, not individualized proof. Meaning the state just said people gonna be scared of her, but they ain't got no proof whatsoever. No proof why they gonna be scared of her. No proof. No proof. All substantiated. All coming from your 9-second witness. All from your 9-second witness. So, Attorney Ari, she said the state failed to prove evidence, presumption is great. Proof is evidence, assumption is great. A real and present threat, and that no conditions could mitigate the risk. and continued detention violates the Pretrial Fairness Act. She literally is going in on the 7th and saying, State Attorney, you failed to prove what you said on the 4th. You failed to prove that proof is evidence and presumption is great. You failed to prove that. You failed to prove that Holly is a real and present threat. You failed to prove that no conditions could mitigate the risk. You failed to prove why she should stay detained. And that violates the Pretrial Fairness Act. That's what she's saying. Right? So she asked the court to vacate the detention and impose conditions instead. So she's going in and she's saying, no, release my client under these conditions. She all right. She gonna be all right. She all right. She ain't no threat. Release my client is what Attorney Ari is saying. Now, we're going to go back. Now, we're going to talk about, well, I think I already talked about the act or the act, the Pretrial Fairness Act. So we talked about that. Now, I think I already stated, but I'm going to state it again, that the factor that the judge must consider on the 7th is Holly's prior criminal history or lack of, threats of pattern of violence, ability to follow the court order, strength and consistency of the evidence. That's important. Strength and consistency of the evidence. So let's pause here for a second. On the 7th, next Wednesday, there will be evidence shown. There was no video played in front of the judge on December the 4th or whenever they went back to court. There was no video played, okay? There will be video footage played. Not only will it be video footage played that show the star witness not being able to see what she says she saw, there will be video footage played to show that she did not hear what she says she heard. But furthermore, there will also be videos shown that there is no fist bump that exists, okay? It's not captured. They do have video footage of after the shots rang. All of that is on video. Nothing in that particular video shows a fist bump. The state attorney do not have it. They do not have it, okay? So what does this mean? What does this mean? It means that there is a high chance, now I'm not going to say 100% nothing because, I'm just not. But there is a very high chance that Holly will be released on the 7th. It is a high chance unless the state pulls something out of their ass between now and next Wednesday. There is a high chance. I would say if I have to give it a number, a 99% chance that Holly will be released on the 7th. Okay? And if not the 7th, maybe the 8th. And the only reason I'm saying that because sometimes it take a minute to process the paperwork. They may say, we ain't going to release you today because somebody might be waiting for your ass outside the court or whatever. I don't know. I'm just saying. But she will, no, I'm not going to say she will. Most likely she will be getting out. There is nothing that the state has proven that will keep her detained. The things that the state read off on the 4th of December is not corroborated. Is not corroborated. So again, I know a lot of people don't want to hear this, but she will most likely be coming home on the 7th. Now, that doesn't mean that she's not going to be found guilty down the line, although, we're not trying to speak that into existence. But this doesn't mean that she is going to be found innocent. This just means that the judge that will hear her case is going to have to go by the law and the evidence The state has no evidence to keep her detained. But the defense attorney did their damn big one, and they went and got the evidence to dispute what the state has said. The state made accusations, and the defense said, whoa, 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 come again and say what now? Say what now? Say what now? What you say now? Say what now? All right. She said, Amore, have you noticed the Ramika fans after calling Holly bitches? Now they're saying, I hope that girl takes a plea because if not, she's going down. Now that gives her advice. No, I have not heard them say that. I mean, I think I heard somebody tell me that, but to be honest with you, I'm not even trying to worry about what they're saying. And so I don't know if you was in my last live, and this is no offense to you whatsoever. But what I'm not going to do is argue with them. What I say on my panel is just my opinion. I'm not about to argue with those people. Like I said on my last live, I realized that everybody elevated don't go all the way up to the top. Everybody don't have comprehension skills. So I just want to stick to my opinion on my channel. I'm not going back and forth with them. It's not up for debate. It's my commentary. And what I challenge you guys to do is don't just rely on the things that I say. Do the research like I do. I do research. I'm not just coming out here and just saying shit. I do research. Okay. And if y'all don't believe me, do the research yourself. Do the research yourself. Okay. So yeah, no, I don't care what they say on their panels, baby. I'm not, earlier I went looking for Tia Irwin's statement or whatever, and I was gonna use somebody that I don't even like. But then I thought about it and I was like, no, because if she used my shit, I'll strike her shit down. So I'm not even going to use hers. I was for a moment, but then I had to think about it. So thank God for a moment of thought. You know, so but again, she said, we're exhausted. That's why I left the ghetto last night. I'm not arguing with anyone. Exactly. It doesn't do any good. I'm not about to argue over something when I can clearly read. Okay. I could clearly read. Now, I want to go over one more thing. So I want to put in this. What is the likelihood? Give me a second. Of Holly coming home on January 7th. Now, again, this doesn't mean 100%, but I think 99% that she will be home. But let's just go into it, okay? This is what it says. Hold on. All right. It says, it says the short answer and the plain truth. It says there is a realistic legal path, legal, not emotional, but legal. There is a realistic legal pathway for Holly to come home on January the 7th, but it's not guaranteed. Okay. Based on Illinois law, release is legally possible and defensible, but it depends on whether the state meets its burden at the detention hearing. Okay. So unless the state come back with new evidence that knocks down the state's motion, then most likely she will be released. But let's continue. It says January the 7th is not a trial date and not a guilt determination. It's all about pre-detention versus release under the Illinois law. This means that the judge is deciding only, is Holly a flight risk? Is she a real provable danger to a specific person or the public? And can conditions short of detention reasonably manage the risk? Okay. Which means the conditions, meaning that the conditions, all the conditions that she said, GPS monitoring, a restraining order, house confinement, all of these conditions. Are you trying to tell me, hey, none of these conditions mitigate the risk? The state's going to have to answer that. All right. Now, again, detention is not a punishment. Illinois legal standard, why release is possible under the Illinois Pretrial Fairness Act. Detention is the exception, not the rule. To keep Holly detained, the state must prove all of the following by clear and convincing evidence. Let's listen. The state must prove the offense qualifies as a detainable offense. All right, that's a yes. She posed a specific articulable threat. Why would she? No release conditions can mitigate that threat. So I don't think that they're going to be able to prove that she posed a specific and articulable threat. And I don't think that they're going to be able to prove that no release conditions can mitigate the threat. If the state fails any one of the three, release is required by law. Let me say that again. If the state fails to prove that no release conditions can mitigate that threat and that she poses a threat, or the offense qualifies as a detainable offense, then the state, if they fail to prove any one of those, release is required by law. Required by law. Now, factors that help Holly chances. There are legally relevant. No proven pattern of violence. One incident is not ongoing danger. Courts look for history of violence, not headlines, okay? A history of violence, right? Again, no proven pattern of violence exists. Self-defense claim, even if they are contested, self-defense claim weaken detention arguments. Detention hearings do not resolve factual disputes. Conflicting evidence cuts against automatic detention. Okay. Ability to impose condition. Judge prefer no contact order, GPS, electronic monitoring, home confinement, or maybe even supervision. If conditions can mitigate the risk, then detention is not justified. Okay. I want to say two things again. Conflicting evidence cuts against automatic detention. There is conflicting evidence. The state says the CTA footage corroborates the witness statement, and the defense attorney is going to prove that it does not exist. That your video footage that you said corroborates your witness evidence does not exist. Right there is conflicting evidence. So that cuts against automatic detention, meaning you can't just automatically keep somebody detained when you can't even prove to the judge what the hell you just said. Again, the judge prefer conditions. GPS, home confinement, supervisor, no contact. If conditions can be managed, detention is not justified. You cannot justify keeping Holly in there if conditions can manage the risk. Now, this is what I'm going to say. Holly was still free for 87 days after the incident. How all of a sudden she is now a threat, okay, to anybody when she wasn't a threat for 87 days. She met all of her appearance. She didn't bother nobody. She didn't get in no trouble. She minded her business for 87 days. Now she's a threat. Now she's a problem. And she didn't have no conditions then. She didn't have no supervision. She didn't have no home confinement. She didn't have no GPS electronic monitoring. And she didn't even have a no contact order in place for those 87 days. Now you're trying to justify detention for what now? What now? It's not going to work. Now, it may have briefed well to keep her detained for Christmas and New Year's, but now it's time for the defense to bring forth the evidence. okay? Bring forth the evidence. Now, the state attorney can argue anything, and it is up to the defense to come and debunk that. And I believe she's going to do exactly that on the 7th. I believe Ari might just be worth the money that they are paying, okay? Because it don't seem like Ari is on no bull crap. It seems like she know what the hell she's doing. All right. So with that being said, detention will not be justified if any of those conditions can manage the risk. All right. Now, it also, hold on, let me see what this says. Factors that also help Holly's chances of being released is community and court ties. Okay. She has family, residence, and no prior failures to a fear. These reduce flight risk arguments. Okay. How you gonna say she's a flight risk and she ain't flighted up out of here yet? She ain't went nowhere. Okay. Now, let's talk about, because we want to be fair across the board. We talked about factors that help Holly's chances. Let's talk about factors that could hurt her chances. Okay. Now, seriousness of the charge. Courts do consider severity, but severity alone is not enough for detention. Okay. How the state frames danger. Prosecutor may argue emotional volatile. They may lean on selective witness testimonies. The judge decides credibility at a high level, not fact finding. Okay. Public pressure. That's another reason that could hurt her chances of getting out. Public pressure. Unofficial, but it's real. Judges are human. High profile cases increase caution. That doesn't override the law, but it can slow release decisions. Okay. It doesn't override the law. Let's get that straight. Public pressure cannot override the law, but it can slow release decisions. All right. Now, the realistic probability of Holly coming home on the 7th. Not a promise, but legally supportable chance of release is very likely. Very likely. Okay. And it says with strict conditions. All right. Now, if they keep her detained, they would have to have a detailed written justification. If the state argument relies heavily on emotions, speculations, or disputed facts, then her chance increases. But if the state presents clear, specific danger evidence, then she won't be getting out. So again, if the state argument relies on emotions, speculations, or disputed facts meaning, like he said, that handshake shit, right? That's disputed facts. Like he said, CTA footage, collaborate my witness. That's disputed facts. What is disputed facts? Things that the defense attorney can dispute with evidence, meaning that she can knock that shit on his head. That is what you call a disputed facts. Disputed facts. The state attorney can't just go in there with speculation. My witness said, my witness said, my witness said. Because then the defense attorney is going to say, where's your witnesses? Because you gave me 4 witnesses. And of the 4 witnesses, 1 witness of all 4 made these allegations, but you put witnesses, sis on there. What happened? What happened to the 2 witnesses said this? The 2 witnesses said that. The 2 witnesses did this. Where they at? Where they at? Oh, you wasn't going to tell us? You wasn't going to tell us what happened to the other? You wasn't going to tell us? You wasn't going to say nothing, state attorney? You was going to keep that to yourself? You wasn't going to say that, state attorney? Okay. 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 So anyway, again, it is very likely that she will be home on the 7th. All right. So we'll just have to wait. We'll just have to see. We'll just have to wait. We'll just have to see. That is what we're facing for next Wednesday. She is not a threat. And if she is, the state has to prove that. How is she a threat? How? Oh, because your witness said she did this and she did that. Well, your witness is non-credible. Your witness is unreliable. Yeah. Your witness, your star witness, she's not a truth teller. Okay. So that's where we at. That's where we are. All right. So again, January 7th is not about guilt. It's about whether the state can legally justify holding Holly before trial. Under Illinois law, detention is the exception, not the rule. Release is possible, but it depends entirely on whether the state meets its burden. Okay? Whether the state meets its burden. Attorney Ari said, you can't meet your burden. You can't meet your burden. What the hell you thought? You can't meet your burden. So, may the best attorney win on the 7th of January. All right? May the best attorney win. Any questions? He says, where they at? She said, where they at? Or where they at? Where are the witnesses? Oh, exactly. So, I listen. I heard that there was so many witnesses. Oh, it's 15 witnesses, this, and the other. Listen, it may have been 15 witnesses, but only 4 of them made a statement. Okay? I do believe that there was more witnesses, but only 4 of them made a statement. Only 4 of them made a statement. You heard me? Only 4 of them made a statement. Okay? That part, 4. So with that being said, unless they're going to pull them out later, she said, I need an attorney more for the future. Girl, I need a damn law degree for real. She said that's what happened, that public pressure from the ops at somebody, and somebody's going to jail if more people come out lying. Oh, so I will be doing a live on probably Monday because I'm hanging out with my husband and my daughter tomorrow. But Monday, I am going to do a live and I'm going to break down, can any witness get in trouble for lying on an official document? Okay. So we're going to talk about that, or lying to the courts. So we're going to talk about that on Monday. All right. Can a witness get in trouble if they get on the stand and lie? And it could be a proven lie. So we're going to talk about that on Monday. I'm going to do a thumbnail and go ahead and get that set up for Monday. We will break that down and discuss if they can, what type of punishment can they get if they lie on a stand, or even to a detective or anything like that. She said, I can't believe the state is really relying on witness number 3. I thought they did their homework a little bit better. They had several months to investigate and come up with something better than this. Sassy D, you are absolutely correct. And I was talking to somebody today and they said, come on now, more. It got to be more than this. The state ain't going to charge her with first degree without any evidence. Like, come on, Amora. It has to be. And I said, there is no evidence. Except for that witness number 3 didn't see what she said she saw, and and didn't hear what she said she heard. But as far as the shooting itself, any threats, arguments, or anything like that, there is no evidence. There is no evidence. She said, serious question. If you know more, is witness number 3 going to be able to testify if this bullshit goes to court? Yes. So I did look that up, and yes. So even if her statement is impeachable, which it is, that does not mean it get thrown out. Just because it's impeachable does not mean it get thrown out. It still goes before the jury, but is looked at in a bad light when it comes to the state's case. because once Attorney Ari or the defense attorney get finished with that witness and have to turn around and basically tell the jury that she is unreliable, inconsistent, uncorroborated, right? They're not allowed to come out and call her a liar, right? But they are allowed to not deem, but what's the word? Prove her to be non-credible, right? So with that being said, they will allow her testimony, and then she has to prove to the jury or whatever, or convince the jury, should I say, that is not reliable through evidence. And I heard that once you do that, the jury kind of looks at it like, basically what it will do, it will create reasonable doubt. And that's why I did that video, my last video. So unsubstantiated, unreliable witness creates reasonable doubt, especially if they are the star witness. Now, if that witness wasn't the only one that said they saw this, said they saw that, said they saw this, blah, 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 and it didn't, if it was more than one witness and their story kind of aligned, then you know what I'm saying, it wouldn't be a big deal. But the fact that their star witness, the one that said, I saw everything, and then they're gonna basically prove that she's lying about what it is that she saw, it creates reasonable doubt. And that's the thing. With reasonable doubt, the state cannot win. The state cannot win with reasonable doubt because they have to prove that it was not self-defense beyond reasonable doubt. Now, I just want to clear up one more thing, and I know I've said this multiple times, but I hear people saying, she's going to have to prove why she didn't do this. She's going to have to prove why she didn't do that. Listen, Holly ain't got to prove a damn thing. Holly ain't never got to make a statement if she doesn't want to. And she probably not going to make a statement. Again, Holly doesn't have to prove shit. Once self-defense is raised, right, then the burden of proof falls strictly on the state. Holly does not have to prove nothing. Holly don't have to prove why she didn't get in a car. Holly don't have to prove why she didn't dial 911. Holly does not have to prove why she didn't run. Holly don't have to prove why she didn't fight. Holly don't have to prove any of that. The defense said that it was self-defense. Her life was in imminent danger and whatever else she's saying, right? And the state have to prove that her life was not in imminent danger. The state have to prove that it wasn't reasonable. The state have to prove that her protecting her child and her kid, her son or whatever, was not, intimate. They got to prove that. They have to prove that the decision that she made was not self-defense. Matter of fact, let me just tell you exactly. I'm going to tell you exactly what they have to prove. So when I hear people say, Holly got to prove this, she got to prove that, she got to prove that, those people are not reading or either comprehending, one or the other. They're not either reading or comprehending. Now, again, I said, what does it say have to prove? It says they have to prove beyond a reasonable doubt. First of all, let's go over beyond a reasonable doubt, okay? What beyond a reasonable doubt actually means. It does not mean beyond all doubt, beyond speculation, beyond imagination, but it does mean a reasonable person has no logical alternative explanation. Doubt must be based on reason and evidence, not vibes or emotions, okay? Now, it says to convict anyone The state must prove every element of the charged offense beyond a reasonable doubt. If one element fails, then there will be no condition, no probability, no emotional convincing, not the jury feels bad. Beyond a reasonable doubt is the highest burden in American law. All right. Now, I'm going to say, I didn't do it for this case. I want to specialize it in this case, what they must prove in this case. All right. So in this case, in order to convict Holly, regardless of public opinion, the state burden does not change. They must prove every element beyond a reasonable doubt. They must prove Holly was the person who fired the weapon. The act caused Ramika's death. This part is not usually disputed in a self-defense case. Admitting the act does not equal guilt. This only moves the case to the next question. The next question is, the most important part, was the act criminal? This is where the case lives or dies. Because Holly has a self-defense claim, the burden shifts. Holly does not have to prove self-defense. The state must disprove self-defense beyond a reasonable doubt. What the state must disprove, and if they don't, one fail equal acquittal. To defeat self-defense, the state must prove at least one of the following: that Holly was the initial aggressor. If the evidence shows Ramika initiated contact, Ramika advanced toward Holly, Ramika ignored verbal warnings, then self-defense survives. Conflicting witness accounts here equal reasonable doubt. Number 2, the state must disapprove. Holly did not reasonably fear harm. The state must prove Holly's fear was unreasonable. The key problem for the state: there were prior threats, documented prior threats. Confrontation occurred close to Holly's vehicle. Rapid escalation. The law does not require physical injury before defending yourself. The law does not require waiting to be struck before defending yourself. The law does not require perfect judgment, only reasonable doubts. So again, the state must prove Holly's fear was unreasonable. The problem that they will have is there was prior threats. A judge told Holly 2 months prior, or not told, but agreed with Holly 2 months prior, that there was legal threats made on her life by Ramika, and awarded her a no contact stalking order. Ordered a no contacting stalking order against Ramika 2 months prior. So that legalized and validated her threats. So again, the state must prove Holly's fear was unreasonable. The key problem for the state here is prior threats. Confrontation occurred close to Holly's vehicle with her 6-month-old child in the back seat of the car. So again, number 3, the state must disprove, should I say, that the force used was unreasonable. Deadly force is justified if the person reasonably believes death or great bodily harm is imminent. The state must convince the jury that no reasonable person in Holly's position would have done this. That is a high bar. especially with a chaotic scene, conflicting witness testimonies, and seconds long decision making. Now, I'm going to go a little further in this one right here. I'm going to go a little further. Give me 1 second. Because I want to make sure we're clear, and then I'm going to come back up. Let's go into unreasonable force again, legally. In a self-defense case, deadly force is justified if a person reasonably believe it is necessary to prevent death, great bodily harm, or a forcible felony. The key word is reasonable, not perfect, not calm, not hindsight based, but reasonable. Okay. Reasonableness is not judged after the fact. The law asks, what would a reasonable person in the defendant's position with the same knowledge perceive in that moment? Not what we know later, what slow motion video might suggest, what social media thinks, and what would have happened if she waited. In that moment, would a reasonable person in the defendant's position with the same knowledge perceived in that moment? In that moment. What the state must prove to say force was unreasonable. The state must convince a jury beyond a reasonable doubt that no reasonable person in Holly's position would have believed deadly force was necessary. Okay? They must show at least one of these. The threat was not imminent. The state must prove there was no imminent danger, no rapid escalation. They got to prove this, though. No rapid escalation. Do you know what rapid escalation means? Now, it's been said that Ramika jumped out her car and ran toward Holly, charged toward Holly. We seen Ramika body land by Holly's car. That alone shows that she was in Holly's area. Okay? So no rapid escalation without video footage. How are they going to prove that? But anyway, the state problem, confrontation happened quickly. Physical proximity matters. Her body landed right by Holly's car. They were close. Don't believe nobody that say she got sniped from the sidewalk. It did not happen. They were close. She got blood on her. She got blood on her car. They were close. Verbal threats plus movement towards someone does matter. Imminent does not require a weapon in the hand, a punch already thrown, or injuries already sustained. The level of force was excessive compared to the threat. The state may argue she used a gun against an unarmed person. But check this out. The law does not say guns can only be used against guns. Deadly force requires the attacker to be armed. Deadly force is justified if a reasonable person fears seriously bodily harm. Size, strength, aggression, prior threats, or persistent exit, meaning there's no way to retreat. If juries think this could have turned deadly fast, force is likely reasonable. Okay? Now, the state must disprove that Holly had a clear, safe alternative. Illinois does not impose a strict duty to retreat. The state must prove a clear, safe option existed. Not know, oh, I'm about to tear up my damn car trying to get on the sidewalk and speed down the damn road. Not that I'm about to hit 5 cars trying to fly over to the other lane. A clearly safe option to exit. The state must prove it was known and available. The state must prove it would have actually reduced the danger. If retreat was unclear, if retreat was risky, if retreat was blocked, If retreat would have increased vulnerability, then force may still be reasonable. The state must disprove, or should I say, did I say disprove? Oh, hold on. The state must prove, oh, I already said that. Oh, Holly continued force after the threat ended. So they must prove that she continued force after the threat ended. This is where some self-defense cases fail, but only if evidence shows the threat clearly stopped, the defendant continued anyway. Seconds matter, stress distorts perception, and law does not require instant judgment perfection. So if the moment was chaotic, doubt remains. That is why the pause between each shot came into play. It came into play because they're trying to say seconds matters, okay? But they have to prove it. They have to have evidence to show that there was a pause between each bullet. They have to prove that. Now, what defense attorney said is they ain't got no proof that there was no pause. She said there was no pause. The state have to prove that it was. The state has to prove that it was. Okay? Now, without assuming facts, legally relevant consideration, close range confrontation near her vehicle, conflicting witness description of movement and aggression, claimed fear of harm, rapid escalation, no requirement that Holly had to be injured first. These factors makes it very hard for the state to prove force was unreasonable beyond a reasonable doubt. All right. So now let's go back up. That's the reasonable doubt one. Let's go to the other one. That was reasonable doubt. Let me go back. Okay, that was reasonable doubt. Now, the state, now we're on what the state must prove for a conviction. That Holly committed the act. Physical act occurred. Defendant is the person who did it. This includes identity, location, and timing. If identity or sequence is unclear, then doubt exists. The act was criminal. Oh, I think I already did that. Okay, hold on. Give me a second. Let's go into how self-defense changes everything. Once self-defense is raised, the state must prove beyond a reasonable doubt that Holly was the aggressor. There was no reasonable fear of harm. Force used was unreasonable, and the defendant was not legally justified. They must eliminate every reasonable self-defense theory. If one survived, just one. If one survived, then acquittal must be acquitted, okay? If one survived, they must eliminate every reasonable self-defense theory. All the self-defense theories, okay? It says one self-defense, okay, the state must prove beyond a reasonable doubt. And it says, or the defendant was the aggressor, or there was no reasonable fear of harm, or the force used was unreasonable, or the defendant was not legally justified. So they have to be able to prove at least one of those. So the state doesn't win by just telling a story. They win by proving every element of the charge beyond a reasonable doubt. And if even one piece doesn't add up, the law requires a not guilty verdict. So again, we'll just have to sit back and wait and see. But yeah, I just think that it's not going to be as easy as people think it is. It's a lot of noise in the media, but that does not mean this noise is going to win a case. It don't mean it's not going to win. I can guarantee you it ain't going to be first degree, but it is not a slam dunk. Oh, she about to be in prison for 20 years. It's not slam dunk. It's not a slam dunk case. I know a lot of people think it is, but I'm telling you, it is not a slam dunk case. All right? It is not. It's just not. It's not a slam dunk case. And the reason why it's not slam dunk, let's just be honest. Her child was there, and that is a very important piece of the problem. People say, oh, her child wasn't in danger. You don't know that. Matter of fact, I'm going to spend about 10 more minutes, and then I'm going to close out. All right, this is what it says. Defense of others. That is a Illinois law concept. It's called defense of others. Illinois law allows a person to use force, including deadly force, if they reasonably believe it is necessary to prevent death, great bodily harm, or a forcible felony to themselves or another person. A child on the scene can legally matter because children cannot defend themselves. They cannot flee quickly. They are uniquely vulnerable. The law does not require the child to already be harmed. All right. Now, what the jury is allowed to consider, this is what they're going to be told. Now, this is if evidence supports it, which means she has to be able to prove that her child was there, right? And I'm sure because I think it's in the report, they know the child was there. If evidence supports it, juries may consider proximity. Was the child nearby? In the car or near the confrontation? Close proximity of the child equals stronger reasonableness. How close was the child? I don't know. I'm gonna leave that one up to y'all. How close was the child? I think the child was very close. The only separation from the child was a door, a car door, Okay. Escalation risk. Was the confrontation chaotic? Was the other person advancing, yelling, or ignoring warnings? Juries can consider, could this have escalated into harm to the child within seconds? Time pressure. Did Holly have seconds to react? Would delay increase danger to the child? The law recognizes split-second decisions, especially involving children. Inability to retreat safely with the child. Even though Illinois law does not impose a strict duty to retreat, this still matters. Retreating while protecting a child is harder. Moving a child can expose them to harm. Turning your back while shielding a child increases risk. This affects whether deadly force was reasonable. Now, it says what the state would try to argue. The state would attempt to show the child was not in any imminent danger. The threat was directly only at Holly, not her son. The child was shielded or not within reach. He was in the car. There was a door. She couldn't get to that child. The state would try to argue force exceeded what was necessary. But they must prove beyond a reasonable doubt that a reasonable person would not have believed the child was at risk. That is a heavy burden. The presence of a child don't automatically justify deadly force. That's not what we're saying here. The jury still have to ask, was the belief reasonable? Was the threat imminent? Was the force proportional? But if reasonable doubt exists about any of those, then they must acquit. Okay? Now let's apply this to Holly. If the evidence shows that the child was present, that the confrontation was close, and that Holly believed harm could reach her child, then the child presence become part of the reasonableness analysis, not a sympathy plea. This can strengthen self-defense claim, strengthen defense of others, undermine claims that force was unreasonable. So, at trial, Holly's son does not matter for sympathy. But if the child was on the scene and Holly reasonably believed that her child was at risk, that absolute matter in assessing whether her use of force was reasonable. Now, we all know threats was made not just to her, but to her child. And guess what? Her child was on the restraining order as well. Not just her, but her child. But also her son. And that's a big piece of the pie that we're missing here. That's a big piece of the pie that you don't hear a whole lot of people talking about. The fact that her child was on the scene increases her reasonable fear of imminent danger. So that will be looked at. She wasn't just there to protect herself. She was also there to protect her son. So we just have to again see how that plays out. But I believe that that's going to be a bigger piece of the pie than a lot of people want to believe. So with that being said, hey, like I said, we shall see. We shall see. But a lot of people are not thinking of their child. They're like, oh no, you know, this had nothing to do with the child. Leave the child out. Well, by law, you can't. By law, you can't, because she threatened their child as well. She literally said, and there's evidence that's going to be shown in court where she said a whole lot of shit about the child. One of them that she was going to spit in the child's face. Another one that she going to bust her head open. And I want to say, now I seen the threat where she said, I'm going to kill you. But the defense attorney put in the motion that she said that she was going to kill the child. I didn't see that threat. I didn't see the threat that she said she was going to kill the child, but it is in the motion. So maybe that's one of the ones that did not enter the court way. You know, maybe she texted that or said it some other type of way. I don't know. She says they acting like Holly had no right to be there with Carlos. Yeah, no, that's emotions. That has no relevance whatsoever. She was legally where she was allowed to be. Okay. She was legally where she was allowed to be. That's emotions talking. You know, she shouldn't have been over there. That's emotions. That don't win no cases. That ain't winning shit. Okay. She said, let's be honest. Holly was never seen on video checking on her child, even after the pew pew. I know the noise upset him. That's not true. Let me take that back. She's not seen on video footage that was shown on TV, but she was absolutely seen on police cam. Okay, so just wait for it. All right, just because somebody had a video camera, they may not have shown her checking on her child, but she was definitely checking on her son. Okay. She said to say you will unalive a child is psychotic, or spit in a face, or some of the other nasty, disgusting things that she said about the son. Yeah, she said she did say, I wish your baby dies when Holly was pregnant. Hold on, let me just get the threats. Let's pull them up right quick. All right, here's some of the threats. So it says explicit threats to K.I. Ramika Blackman allegedly called Holly's grandmother twice and stated, I'm going to kill your granddaughter, Khadijah. She called Holly multiple times and stated she's going to kill me. Threats of serious body harm. Ramika Blackman allegedly stated she hopes me and my baby die. Oh, she did say that. So September the 28th, she hopes me and my baby die. She's going to bust my head open when she sees me. She allegedly told Holly close friend Rebecca that she's going to beat my ass. It says pattern of repeated harassments and stalking type conduct. This document alleged repeated conducts over months, including numerous phone calls from unknown numbers that Holly stated that she tracks back to Ramika's phone and her son's phone from October the 29th to the 30th and November the 7th, October the 9th at 2 a.m. Multiple days of repeated calls asking where Holly was and what Ramika was going to do to her. Repeated texts and calls dating back to August and September. Voicemails left on multiple occasions. Repeated contact via Instagram, including as recently as May the 13th. Threats involving Holly's family and child. Statements referencing Holly's baby, September the 28th. Alleged attempts to locate Holly's grandmother, Holly's mother phone number, Holly's grandmother phone number, Holly's home address, including contacting Holly's mother, Holly's grandmother, Holly's friend, and telling Rebecca that she had the grandmother's address. Violent observed or alleged during the call. Holly alleged that during one call, she could hear Ramika hitting Carlos while her son was saying, stop hitting my daddy. Okay. It says, why do these threats matter legally? They are relevant to the state of mind. At trial, threats can be relevant to whether Holly's fear was reasonable at the moment force was used. The law allows juries to consider prior threats, escalating behavior, targeting of family members, threats involving a child. This goes to reasonableness, not sympathy. They support defense of self, defense of others. And if a jury believed these threats occurred, Holly knew about them, the confrontation escalated quickly, her child was present or nearby, then those threats may support a reasonable belief of imminent harm. All right. It says important limits. Allegations in a restraining order filing are not automatically proven facts. The defense must connect knowledge of threats to the moment of the incident. The state may challenge timing, credibility, or cooperation. Threats do not guarantee acquittal, but they absolutely matter in a self-defense analysis. All right. So according to the restraining order filings, there was repeated threats to K.I. Holly, threats involving her baby, and months of alleged harassment. If the jury believes those threats were real and known to Holly, they are legally relevant to whether her fear at that moment force was used was reasonable. Oh, you know what? Hold on. That was just the application. Give me 1 second. So I put in that the order was granted by default. And it says by the preponderance of evidence, okay? And that's what it says, all right? And preponderance of evidence is basically saying it's more likely than not that this is true, all right? So now, preponderance of evidence, this is a civil standard of proof, meaning more likely than not, 50% or greater, all right? Now, with that being said, it says, what the judge actually found. By granting the order, the judge found that Holly presented sufficient evidence of threats or harassment. The legal threshold for protection was met. Court intervention was justified to prevent harm. All right. So now it also says, how can this help in a criminal case, Holly's criminal case? What it helps with, the order can support argument that Holly had documented court recognized fear. Her fear was not evented after the incident. The threats were taken seriously by a neutral judge. Her state of mind may have been reasonable. This matters in self-defense cases, defense of others, and reasonableness of fear. All right. Now, basically, it says this order doesn't decide guilt, but it shows that before this incident ever occurred, a court found that Holly's fear was more likely than not based on the documented threats. That contents matter when evaluating her state of mind. All right. The protection order was granted by default under a preponderance of evidence standard. That does not decide criminal guilt, but it does mean a judge found Holly's fear and the alleged threats credible enough to warrant court protection. A jury can consider that context when evaluating whether her fear at the time of the incident was reasonable. So she had documented fear. By that restraining order being signed by the judge on July the 14th of 2025, that made her fear documented. And it wasn't just for that moment. She had documented fear prior to this situation. So it wasn't spontaneous. It was ongoing. So anyway, documented fear, she already had it. She already had it. And that is what Attorney Ari will also be focusing on. So even though it was granted by default, she still had to show reasonable proof to support her claim. Yep. And she did. So she has receipts. I just want to know, do she have to show those receipts? It says yes, at trial, Holly cannot rely on the restraining order alone. If the defense want the jury to consider these threats, they must be supported by admissible evidence. So yes, she will have to show these receipts. And guess what? honey, we gonna see them. You hear me? Unless they close this case down and allow us not to see any of this, the whole damn world is about to see all the evidence, all the receipts. Y'all know when we was doing the Jonathan Major case, we saw all them text messages where he was telling that girl that he was gonna off himself and telling her that, you know, if she goes to the hospital, he's gonna get in trouble. And she's like, but I'm hurting. And he's like, but you're gonna ruin me and all that. Remember that? So we're going to see the receipts that Romika sent to Holly. We're going to see them. We're going to see, we might see more than we want to see, baby. You hear me? Because, baby, I heard some, baby. There is some receipts. We're going to see just how Romika spoke while she was live via text message, baby. We're going to see the video footage that she sent of herself, baby. We're going to see this. We are absolutely going to see the receipts unless they close down a case, which I don't believe they will, but we'll see. But we want to see. She said, I damn near want to go up there on the 7th. You so funny. Go on up there, girl. But you're not going to see the receipts on the 7th. That's not going to come out on the 7th. That's going to come out during the trial. So the only thing you're going to see on the 7th if you go is the video footage of the CTA cam and any camera around the area or whatever. But you're not going to see the restraining order receipts on the 7th. No. That's going to be for trial. For trial. They're not going to try the case on the 7th. So you won't see anything on the 7th that's going to be used in the trial. Well, I shouldn't say that's going to be used in the trial, but, you know, you're not going to see that on the 7th. So anyway, she said, 100K, man, I'm traumatized. You traumatized, Truth in the City. Girl, what you traumatized for? Why you traumatized? She said, I need your support so I won't go looking for Carlos in a bulletproof vest. I need to go to bed tonight. She is talking about them right now. Real TV talking some hot stuff. Oh. So anyway, she said, and Romika could have contested the order. Yeah, so she had 30 days to contest the order and she did not. So you are absolutely right. I want to say it was 30 days, but yeah, she had so many days to contest the order and you are right, Kathleen, she did not. She did not. Okay. Hope we learned some things today. Again, you know, it is what it is. You know what I'm saying? We will see a lot here real soon. What's her name? Raina Carter said they have to prove them. If it's no proof, they don't matter. Oh, baby, it's proof, baby. It's a whole lot of child. Honey, all I got to say is grab your wine, child. Grab your wine. Grab your wine. Listen, the proof is going to be in the pudding. Honey, we all about to see just how much she terrorized this young lady, child. Just how much she terrorized this young lady. So anyway, baby, thank you, Angela. She said, great live. I love how you break everything down. Thank you so very much. I hope that we got something out of today's live because, baby, it is what it is. You hear me? A lot happened. A lot is not being shared. A lot is being withheld. But, hey, it is what it is. So this is not a cut and dry case for the state or the defense. For the state or the defense. It's not a cut and dry case. So, you know, I mean, I think a lot of people have wishful thinking, you know, but I believe that the more evidence come out, I think we will get a little clearer. And hopefully once some evidence come out, people will stop spreading some of the lies. But we ain't gonna worry about the lies over here because, you know, I ain't gonna listen to them. I'm not listening to no more lies. I ain't listening to none of it, okay? I will listen to what the state attorneys say and the defense attorney. I'm going to mind the paperwork and the law and my own interpretation of it. Okay. I don't care what nobody else say. Our comprehension skills are not the same. Absolutely not. Okay. So thank you everybody for the birthday wishes. Great live and more. Thank you, Lorraine, and happy 55th to you yet again. Okay. All right, y'all, I'm about to get off and I am going to enjoy the rest of the evening. And I hope that you guys do the same. Thank y'all so very much for pulling up. Thank you, Lorraine and Glenn and Lady V and Sassy D and Joanne and Gloria and Lady Love and Vanita and Jones. How you say that? Joan Zoon. I'm just gonna call you Joan. And S Gums and Angie and Lorraine. Thank y'all so very much for blessing me on this live stream. Y'all hit that thumbs up button on your way out and enjoy your evening. Love y'all. Bye.
Because they can't make $1 without mentioning down one of our names.
Yay! She kept talking about
We
that
got these
family.
hoes over there.
She kept talking about that family. She kept talking
Internet
about that
gangsters.
family. She kept talking about that family. She kept talking about that family. That family. She kept talking about that family. Talking about that family.
These motherfuckers got me want to regret something. Because they can't make $1 without mentioning down one of our names.